May it please your lordship. কোর্টের মাইক আনমিউট করে নাই। ট্যাবের দ্বারা কথা বলছে, লিঙ্ক হচ্ছে না ট্যাবে। May it please your lordship. অমিতকে বলো তো কোর্টের মাইক আনমিউট করে নেই, ফোন লাগিয়ে দিচ্ছে। ফোন করে কখন মেসেজ ছাড়া যায় আনমিউট কোর্ট মাইক, এটাতে নাই তো। বাটন নেম বলে নাম্বারটা বলে।
Yes, please proceed.
May it please your lordship. My lord, am I audible to your lordship?
Yes, yes.
My lord, the appeal has arisen out of an order passed in a suit. Now, the suit has been registered in the trial court as a commercial suit. Now, after the order has been passed, there is an order of injunction which is under challenge in the FAO. Now, in the FAO, my lord, an objection was taken regarding the maintainability of the appeal before this honorable court, because the ground taken is that the appeal would lie before the court of the honorable district judge. Now, in support of that, my lord, a notification of this honorable court has been, I mean, notification issued by the government of Assam has been placed on record. And because of that notification, the honorable court, which was dealing with the matter, was of the opinion that it should go before the commercial bench of the High Court. Accordingly, it was listed before the court of the honorable Justice Devashish Borua. Now, his lordship was of the opinion that since his lordship was not taking up the civil bench one roster, so the matter was placed before the honorable Chief Justice for passing appropriate order. Pursuant thereto, my lord, this matter has been listed before your lordships. Now, my primary submission is this, my lord. Although, my lord, there is a notification stated to be issued in the year 2019 in pursuant to the commercial court's ordinance. Well, the commercial court's ordinance was superseded by the Commercial Courts Act in the year 2008, August 2008. And the notification has been passed in the year 2019 pursuant to that lapsed ordinance. So in that view of the matter, my lord, the commercial constitution of the commercial court itself is not proper. So in that view of the matter, my lord, the FAO has been filed under Order 43 Rule 1R, requiring, my lord, the appellate court's consideration over the order impugned. That is how, my lord, the matter has been placed before your lordship.
সিলিন্ডারটা বলে দিল উন্নয়নকে আমি এখন সফট কপি থেকে দিয়ে দিচ্ছি আমার ফাইলটা আছে না নেয়নি ফাইল আসুক ফাইলটা নিলেই হবে হার্ড কপিটা বলছে আমি দিচ্ছি সফট কপিটা দিয়ে নেয়নি নেবো না সব কোড বসেনি ইন্ডিয়ান মেনশনটা করুন সমস্যা হলে উকিলকে জিজ্ঞেস করে যে জেনে নেবে এটা নিজে নিজে দিবে। হিয়ারিং হবে না, ইনজাংশনে হিয়ারিং হবে না, ওটা হবে না, মেনটেনেবিলিটির উপরে।
Your Lordship. Lordship, there is a preliminary issue that needs to be addressed by this court as well. It's with regard to the maintainability of the appeal. Whether the
My lord,
appeal,
I am addressing your lordship on that only, my lord. Because the question of maintainability has been raised by the learned counsel for the respondent,
You
my
have
lord.
raised
That's
it
why
as
I am
the-
addressing your
responding to
lordship
it.
on this.
Your
You have
Lordship,
raised it, you have referred it to.
Your Lordship,
you have
there is a
referred to the law.
saving,
Let
with
him
that regard, I
please-
would like to submit that there is a saving clause as well. With regard to the repeal of the ordinance, Your Lordship, there is a saving clause as well, Your Lordship. So the provision stands. Lordship, I humbly submit that this appeal is not maintainable before this honorable court. The appeal has been preferred against an order passed by the Civil Judge Senior Division, that is the Commercial Court. And as per the express provisions of the Act, the appeal will lie before the District Court of Jorhat, Your Lordship, as per Section 13(1). Your Lordship, I would like to take Your Lordship to a few provisions of the Act, Your Lordship.
My lord, before my learned friend argues, my lord, may I just conclude my submissions?
Yes, yes. We thought that you had completed your submission.
No, no, my submissions are basically on a very simple premise. Section 3 speaks about the constitution of the courts, commercial courts. And in terms of Section 3, my lord, the notification has to be issued by the state government in consultation with the concerned high courts. Now, here the notification that is now being praised into service, my lord, that's a notification of 2019. It was passed on 13th of February 2019, and it was issued under the provisions of the Commercial Courts, Commercial Division, Commercial Appellate Division of the High Court, Amendment Ordinance 2018. Now, this amendment of 2018, it was superseded, as I said earlier, my lord, it was superseded by the Act which came into existence on August 2018. Now, after the Act had come into, effect, well, this ordinance is of no consequence. Number one. Number two, the saving clause, my lord, will also not come into operation because of the fact that saving clause will take care of the actions, only those actions which have been taken under the ordinance 2018. That is, during the
20,
currency of the
Section 20
currency of lordship. Lordship, I just missed out, possibly.
Before that, my lord.
There are two other notifications. One notification is dated 10/5/2023.
Yes, ma'am.
The other is 2/6/2025. Where are those
No.
notifications?
We have, my lord, before that, my lord.
No, do you have the
I
notification?
have, ma'am.
Please, please,
My
please.
lord. Sorry.
Now, if your lordship permits me, my lord, then I can address your lordship on these two notifications. One is 10th of May 2023, and the other one is 26th of September 2024.
Yes, please proceed.
Yes, now, my lord, 10th of May 2023 is the notification, my lord, which has been issued under section 5 of the Act. Now, section 5, if your lordship will kindly have it from the Commercial Courts Act 2018. I mean, my lord, after the amendment, my lord, that is section 5 speaks about composition of the Commercial Appellate Division. So that is the Commercial Appellate Division which has been created in the High Court, and the Honorable Chief Justice has been pleased to constitute the bench with your lordships as the appellate bench of the Commercial Appellate Bench. And so far as the notification dated 26th of September 2024 is concerned, that is with regard to the commercial creation of the Commercial Bench of the High Court. Now, Commercial Bench of the High Court will deal with only those cases, my lord, which are directly filed before the Commercial Bench because of the jurisdiction created under Section 13. Now we are at the level of Section 3. Section 3 says about creation of the constitution of the commercial courts at district level. Now, in my submission, my lord, district level commercial courts, whatever is being now pursued in terms of the notification of February 2019, that is, my lord, inconsequential, because that is already under an lapsed ordinance. And if your lordship will kindly have the saving clause, that is in the Act of 2018, Amendment Act of 2018, well, that will save only those actions, only those acts done under the provision of the amendment during the currency of the amendment. It is not to save something which is done after the amendment is repealed or replaced by the Act. So therefore, in my respectful submission, my lord, this appeal will lie before the civil bench 1 of this honorable court, because there is no, the suit cannot be understood to be one filed in a commercial court. And consequently, my lord, the appellate, I mean the constitution of the appellate forum at the district level is also not there. So by operation of Order 43 Rule 1R, my lord, this appeal will lie before the honorable single judge of this honorable court, taking up as the roster permits, my lord, taking up the civil bench 1.
So, Lordship, in that case, they have to challenge the notification of 2019 as well, if they are saying that there are no commercial courts in the state of Assam. Without challenging the notification itself, Your Lordship, they cannot argue the matter before the civil judge, civil bench, Your Lordship. And Your Lordship, with regard to the maintainability issue, as I have submitted, this appeal is not maintainable here. Your Lordship, I would like to take Your Lordship to a few provisions. Okay, first is Section 3 of the Commercial Courts Act. The state government.
Just tell me, in this suit which you had filed,
Yes, Your Lordship.
was registered as a commercial suit.
Yes, Your Lordship.
Do you have anything to show that the what do you call this?
That it falls within the.
Pre-mediation which is required.
Yes, sir, we have completed it, Your Lordship.
Where is that?
The order is, I have to see, Your Lordship. We have completed the mediation process, Your Lordship. They will agree. Pre-mediation. Your Lordship, here is the non-starter.
Yes. That's all.
No, Your Lordship. With regard to the maintainability, as I was submitting, Your Lordship, we kindly come to Section 3(1) of the Act, Your Lordship.
Yeah.
Your Lordship, the state government may, after consultation with the concerned High Court by notification, constitute such number of commercial courts at district level as it may deem necessary for the purpose of exercising the jurisdiction and powers conferred on those courts under this Act. That is section 3(1), your lordship. The provisos are not relevant because this court does not have original ordinary civil jurisdiction. Your lordship may come to section 3(a). Except the territories over which the high courts have ordinary civil jurisdiction, the state government may, after consultation with the concerned high court, by notification designate such number of commercial courts, commercial appellate court at district judge level as it may deem necessary for the purposes of exercising the jurisdiction and powers conferred on those acts and under this act. As per these two provisions, your lordship, the state government has issued notification dated 2019, your lordship, by which the in every district, the civil judge senior division has been designated as the commercial court and the court of the district judge has been designated as the commercial appellate court. Your lordship may kindly come to section 5, your lordship, the commercial appellate division, which is this bench.
Listing allow them. কবে? কালকে। ওইটা। তো দুদিন ফাইলটা ঘরে ছিল করে রাখতে পারেনি। আমার চেম্বার করে আমি এইসব করতাম না। আমি ওসব করতাম না। তো এসে না করার ধান্দা করতে পারো। মোদিকা এসে না করার ধান্দা করতে জানি করবোই। রিজয়েন্টটা দিয়েছি তো যাই দেখো সিগনেচারটা আমি মিটিং ছিলাম মিটিং এখনো হাতে দেয়নি, এটা পেয়ে গেলে ভালো ছিল। সেখানে তো তোমার কালকে অন্য কেসটা কিছু করো। ম্যাক্সিমাম যেটা করতে পারি একটু করতেই হবে কালকে, ঠিক আছে একটু করে দেখো। সকালে এটা দুটো একটা করে একটা উঠবে।
একটু করবো।
একটু করে মোশন তো সকালে উঠে যাবে তাহলে একটু করে একটু
পিসিতে আছে, এটা আছে ধরো।
হ্যালো হ্যালো এই আমার পছন্দ
নোটিফিকেশন
ও বলছে
থার্সডে ফ্রাইডে করা যাবে না। কতগুলি করবো জান, করতে গেলে একটু দেখে করতে হবে, নোটিফিকেশন করতে হবে না। থার্সডে ফ্রাইডে আমার মোশন করতে হবে না, এটা করার বাকি আছে।
ওই করবো তো
হ্যাঁ, দেবাশিসের কাছে রিচ করে গেলে মুশকিল হতো। আফটার ভ্যাকেশন করে ফেলেছে থার্ড ফ্রাইডে।
Very to both of you, is there any
Yep.
other notifications relating to the powers of the appellate? Commercial appellate bench?
Nothing has come to our knowledge, Madam. We have also find out.
Milord, we have checked with the registry, Milord. These are the only 4 notifications in existence.
Your lordship,
Now, so far as the the power of the appellate bench is concerned, Milord, as far as I can understand from the reading of the provisions of the Act, Milord, the appellate bench will have jurisdiction to decide the matters only when the commercial bench of the High Court has decided some issues one way or the other. Then only the matters will come before the commercial appellate bench. The High Court has a commercial bench created in terms of notification of 2024, which is before the Honorable Justice Devashish Barua. And the commercial appellate bench constituted with your lordships, my lord, that will be coming into operation only in respect of orders which are passed by the commercial bench of Honorable Justice Barua. So far as this matter is concerned, my lord,
কি বলছে কি বলছে ইনসিস্ট করতে গেলে তখন
ফ্রাইডে এঙ্গেজমেন্ট বহুত আছে, দুটা করার আছে। এই কেসটা যদি কোনো কারণে এখানে স্লিপ করে আমাকে জোরহাট যেতে হবে এটা করার জন্য শুক্রবারে। কিভাবে করে কেস রেখে দেবো?
একটা কাজ করো ট্রেনিং দিতেই থাক বলে রেখে ট্রেনিং দিতে থাক
ভালো বিহুর পরে ভালো, আর যদি না হয় তাহলে ওপেনিং ডেতে রাখ। শেষ করে দিলে পরে কি হতো?
Usually from Shillong is going to Jorhat.
No. He's likely to go to Jorhat on Thursday.
Will be here in Shillong till Wednesday. Hello,
Appellant. And Mr.
Anand Datta.
Anand Datta, Learned Counsel for the respondent. List on Thursday, 18/12/2025 for delivery warrants. Grateful.
May I please, your lordship? My lord, with your lordship permission, my lord, I beg to mention item number 35 and 42 of supplementary list, my lord. Lordship will be pleased to take up both these matters at 2 p.m. my lord, if possible. 35 and 42, my lord. 35, 36 and 42. my lord.
You want to?
Upgrade, my lord. Upgrade, my lord, for upgradation. Maybe taken at 2 p.m. my lord.
Okay.
My lord.
Deep level.
Example 32, 23, 20, 21, 22.
Series matter.
20.
This is connected with item 20 and 21 also. Please wait till we call the matter, then renew the prayer. Because there are two other matters.
Yes, my lord. Item 17.
We are mentioning all.
I mean,
Item
17, 20, 21, 22, 23.
No, these are what do you call? These are what do you call tag matters.
Yes.
So for joining the tag matters, we'll pass orders when we take up the matter, because otherwise we don't know.
Obviously.
You just will allow your prayer, but let us have this. You can tell him to.
May I please, your lordship. Lordship, I beg to mention item number 24, lordship.
24,
lordship. Due to some personal difficulties, lordship, my senior counsel is out of station, lordship. Lordship, adjourn the matter for the day, lordship.
24.
Item number 24.
also they presented. The prayer meeting and conference with Krishna. Just for 2 weeks.
Lordship, after vacation, lordship.
Next.
Yes, lordship.
May I please, the lordship, I beg to mention one repetition, my lord, to come up for admission after vacation, my lord, on 7th January.
You make the mention when it is after the vacation.
After vacation.
May I please, your lordship,
My lord, an affidavit in reply filed on 11/12, my lord. Record may be false, my lord. Highly obliged.
My lord, item 10 may be passed upon. Maybe adjourned. Item 10 is a matter of series. We are not adjourning it. Let the matter be obliged.
Item 1 for motion.
Lordship, in this matter, petition is already on interim lordship. It may be taken up for admission hearing.
Lordship.
I think he instructed part of it. আপনার পাখর পঠিয়াই দিছে না সেইটো সেইদিনা লিষ্টতে আছে দেখো নহয় এইটো নহয় এইটো নাজানো
Lordship. Lordship, a record is received, so we may come up for admission, Lordship. Lordship, Lordship.
Without requiring any fresh steps to be taken. Next, it is the matter for hearing in the first week of February 2026.
Obliged, Lordship.
Item 2 for motion.
My lord, matter may be closed, my lord. What is the copy?
The copy trigger.
For copy is in one.
Waiting upon this move. Because of how like after আমি চাই লগালে কৈ দিব পাৰিব
Okay. But Mr. R.S. Chauhan, the petitioner, and also for the respondents. This will be.
কোলাঘাটে না ধরা ফেরাও
So the matter was listed previously on 8/12/2025. The learned CGC had produced a copy with instructions to the effect that the father of the petitioner from namely Muhammad Hajar Ali, declared foreign national, was handed over to the BSF. First of all, as per the list, the name of the father of the petitioner appears at serial number 108, and he has been sent to the sent back to the country of his origin in the intervening night of 26th of the 27th May 2025 from the area of responsibility within bracket AOR of 89 Battalion BSF. Accordingly, having heard both sides, the matter is closed. Without prejudice to the right of the petitioner or the foreign the declared foreign national, take such appropriate stepping is may be so advised. You proceed without prejudice to your right to have any.
Item 3.
Yes.
In this case, my lord, the petitioner along with one of the family members, my lord, visited the detainee and obtained the signature on the vocal order.
So we close this matter. Mr. S.A. Ahmed, learned counsel for the petitioner has submitted that pursuant to the order dated 8/12/2025, the petitioner and one family member had met the declared foreign national at the holding center at 7th Assam Police Battalion in Soraikula and obtained the signature in the Bukala command. That's so for the respondents present accordingly. As the purpose of this habeas corpus petition has been served from the magistrate's closed. Without prejudice to the declared foreign national to take such steps as she may be so advised.
Item 4.
Same order, lordship. Item 4 also would be the same order.
Lordship,
Your
lordship.
material,
Yes, lordship.
same order. Mr. S. Sudha, along with Mr. S.A. Ahmed. Your name?
N Hop, lordship.
And along with Mr. N. Hopland, Council for Petition. Last order dated 8/12/2025. Same order.
Lovely.
Item 5.
Same order, good.
Similar to item number 3, madam.
Same. Same order, Mr. S.A. Ahmed.
Oblige.
Item 6.
Instructions, so he has been sent back to Bangladesh. Into civil also. Into civil. Appendix it's 39 and appendix C 54. This last six. Is it? Rated over 13. No, Mohammed English only. না ইংলিশ দিব নোৱাৰো আপোনাক।
We record this and we give you time to take instructions. We record his submission and give you time to obtain instructions.
Yes, Milord. Milord, item number 37, Milord. Both are brothers, Milord. Same day picked up.
Okay.
One is pushed back Bangladesh, one is staying at holding center at Pukrazar. Abul Ali, 37
Okay,
item.
one by one, we'll just pass the order here. Mr. A.M. Ahmed, when counsel for the petitioner is present.
57 আমি লাইনত লগাই দিছো।
Yes, I mean, not to deport us.
This is so-and-so for the petitioner and so-and-so for the respondents are present. Next paragraph. Pursuant to order dated 10/12/2025, Mr. M.R. Adhikari, Lanet sees he has obtained written instructions from the Frontier Headquarter, BSF, Guwahati, to the effect that the declared foreign national, namely Mohammed Mohib, MOHIB, Ali, was declared to be a foreigner by opinion dated 22/6/2012,
Yes.
passed in FPG 519 of 2007, has been sent back to Bangladesh. Stop. Relief from the court is inclined to adjourn the matter so as to enable the petitioner to the London Council for the petitioner to obtain instructions. Next list. You will read after the petition. Item 37.
Yes. 28 January.
In item 37. It is item 37.
It is better than you.
Heard.
In 37, there is a IM Milord. His brother Milord.
আইএফও কেন আছে?
I yes for
12 Milord. $79 years Milord. Suffering from burial in moreover, in this case, Milord, petitioner's other brother and sister declare Indian Milord.
Ms. Verma, you take instructions about the petitioner is claiming to be 79 years. Take instructions, we'll take it up on Thursday again.
37, Lordship, item 37.
Yes.
Yes. Claiming that the petitioner is 79 years of age. You're taken into custody when?
Milord, or 24/5/2025. Along with item number 6 Milord.
Lordship, both may not be tagged because six has,
It's already-
Yes, yes.
six has already
Yes,
gone
yes.
back, Lordship.
No, that
My
we are
friend
not
is
tagging
again
it.
confusing, Lordship. Six has gone back.
No, we are not tagging it.
Yes,
He
Lordship.
says that he is the brother, but
Brother.
he's shown be 79. Just get
I'll
instructions
get
regarding it.
instructions on this, such matters may not be tagged. One who is deported and one
No,
who
we're
is
not
here.
tagging it. We're not tagging it. But Mr. A.M. Ahmed, my classroom assessment, and so and so for the responses. Next one. Ex parte opinion is at page 45, dated 27/11/2015. Passed by so and so and so and so. Thereby declaring him to be a foreigner post 25 to 1971 stream. Where is the opinion?
Opinion, the page 24.
24.
Yes.
But then, Mr. Ahmed, we'll have to dismiss this writ petition 2012 opinion.
Yes.
You appeared and took time, and thereafter you were absent.
In this case, my lord, other brothers and sister already declared Indian, my lord.
That is subsequently,
Yes.
those opinions were not there. That is for the state to decide what to do about those people who are declared Indian.
Page 15, my lord. Other brother and sister declared Indian, page 48.
Page 48.
Yes.
No, that is a subsequent decision. That is for the state to decide what to do about your brothers and sisters.
Once.
But this is 2012.
Yes.
You appeared and took time. And thereafter you stopped appearing 15 days, still the dates were given. So the subsequent, the opinion would not override. 2012, the challenge is now after 13 years.
And Lordship, that too, maybe when we started searching for them recently, Lordship. Most of the ex parte opinions have now come before this, for the police have been searching for them.
We'll put the issue of maintainability, you make your submissions, we'll take it up on Thursday. But Mr. A. M. Ahmed may pass over the petition, so also for the respondents. Opinion is page 24, dated 12/6/2012. Passed by so and so, in case number so and so, thereby declaring the petitioner to be foreigner of 25 and 19/6/2012. Post 25/3/1971 stream. The learned counsel for the petitioner submitted that by a subsequent opinion dated 27/11/2015, the brother of the petitioner has been declared to be an Indian and not a foreigner. Next paragraph. As the opinion dated 27/11/2015 was pronounced after the ex parte opinion in the present case, Court is inclined to Here the learned counsel for both sides on the preliminary issue of maintainability. As the party opinion has been challenged. After about 13.5 years. Expired on 18/12/2025.
Lordship, I pay for copy,
Sir,
which is
just-
hard
okay.
copy, Lordship.
In the meantime,
And soft copy.
till the next date of listing, the petitioner was stated to be in custody. And presently lodged at the holding area. Seventh AP Battalion, Command Saraikola from Pokrajak shall not be deported out of the country. Most of the prayer made in the interlocutory application shall also be considered of the next date of listing. You take instructions about the age. Yeah, you should be taking up on Thursday if your maintainability is kept open.
Please.
Get a copy, download
Ah,
the
yes.
copy to give.
Dim. As it is.
Don't copy distinction. Need to do it.
Oh, muito difícil. Please.
Always have to do it.
Item 7.
May I please, Your Lordship? Your Lordship, this is a 226 petition seeking protection of the petitioner's fundamental rights that in under Article 14, 19(1) and 21. These all are arising out of the registration of multiple FIRs, Your Lordship, across different police stations for single cause of action use. It is only one incident for which these multiple FIRs have been registered.
Why consolidation petition will come here? It is to go to the single judge. And why you did not make a prayer before the courts below under the CRPC? If there are 3 cases registered, it can be clubbed together. How many cases are there? Only 2 cases
My lord,
are here.
so far my knowledge, my lord, is the 3 cases now, but we have apprehension that multiple other cases are also filed in other districts.
You see, CRPC has a provision for the 3 cases to be taken up together. Why did you move the division bench?
My lord, if I, for this question before by under CRPC, then my lord, I have to make several petitions for each and every single FIR. And your all,
What is the difficulty?
my lord, the grievance here is not,
There.
my lord,
The provision is there now. And
the grievance here is not the question of the FIR, my lord, here. My grievance, my lord, here is the abuse of the process arising from the successive FIR across the different police stations for the same cause of action, my lord. Well, here genesis of this dispute is, my lord, the
Same person has filed 3 FIR.
no, the person is different. One is the police officer, one is the individual, and other I have no information. I've just got this information from the social media.
You have a statutory remedy. Why you don't apply there? You not exercise. Yes, yes, this is.
Moi, the special relations. People. Okay. No, no. Por eso ustedes funcionan, no pelar. Pero, so what is the protest to see? Protest to see why is the pushing the facility? Pero, pero tapelo. Yo go go I just feel go kan bana ke. Kata ke so night hours.
No, under 219, you'll have to make application before the concerned police station.
My
So that
lord.
it can be charged together.
Yes, sir.
For 9. You're not exercising jurisdiction here.
My lord, I humble submission, my lord, here. My lord, here, there's certain law, my lord, in TT Anthony judgment, where the Honorable Supreme Court has laid down some principles that no second FIR can be lodged, or the second FIR is the impermissible.
Is it impermissible word is used?
Yes, my lord, is second FIR. My lord, is 2001 6 SCC,
Sorry,
181.
show the copy.
So, no, I am not having any clear copy actually. Well, in Arnab Ranjan Goswami also it was the same principles are laid down. Arnab Ranjan Goswami was a union of
No,
India.
if you have the judgment, tell us. You have used the word impermissible. Is impermissible word used there? You are saying yes. Now, what is that citation, T.T. Anthony?
E.T. Anthony versus State of Kerala and others.
Citation?
2001 6 SCC 181. And another is 2020 14 SCC.
Don't take one by one. You have not yet seen one. Yes, which paragraph says
No, paragraph 27, my lord.
T.T. Anthony?
The above list as noted is illustrative and not exhaustive, a just balance between the fundamental rights of the citizens under Article 19 and 21. Have you also got it? A just balance between the fundamental rights of the citizen under Article 19 and 21 of the Constitution and the expensive power of the police to investigate cognizable offence has to be struck by the court. There cannot be any controversy that subsection 8 of the section 170 CRPC empowers the police to make further investigation, obtain further evidence, both oral and documentary, and forward a further report or reports to the magistrate. In Naran's case, Sopra, it was, however, observed that it would be appropriate to conduct further investigation with the permission of the court. However, the sweeping power of investigation does not warrant subjecting a citizen each time to fresh investigation by the police in respect of the same incident giving rise to one or more cognizable offences consequent from filing of successive FIRs, whether before or after filing the final report under section 173(2) CRPC. It would case of abuse of the statutory power of investigation in a given case. In our view, a case of fresh investigation based on the second or successive FIR not being a counter case filed in connection with the same or connected cognizable offence alleged to have been committed to the first FIR, either investigation is underway or final report under section 172 has been forwarded to the magistrate, may be a fit case for excess of power under section 482 CRPC or under article 226 of the Constitution. Coming to the facts of this case, which are not free from political overturn, the incident which gave rise to registering a FIR took place on November 25, 1994, on the occasion of the visit of the minister so and so for innovation of the the next relevant portion on the next. A comparison, same para, the last part, a comparison and critical examination of FIRs in crime number so and so of, and one hand, and FIR in crime number so and so on the other. Disclosure that the date and place of occurrence are the same, whereas alluding reference and 354 of 1994. In any event, that fact was evident on the same scene of are almost the same. The additional averments in crime number so and so regard to the test laid down by this court in Narang case, Supra, with which we are in respectful agreement, we find that in truth and substance, the essence of the offense in crime number so and so is the same as in crime number so and so of so and so. In our view, in sending information in regard to the same incident, did you enclose a copy of the report of the Commission of Inquiry to the Inspector General of the Police for appropriate action? The Additional Chief Secretary adopted the right course of action. Perhaps the endorsement of the Inspector General of Police for registering of a case misled the subordinate police officers, and the said letter with regard to the incident of November so and so at Kutharamba was registered again under section so and so, which would be the second FIR, and in our opinion on the facts of this case was irregular and a fresh invasion by the investigating agencies unwarranted and illegal. And same thing is reiterated in the judgment of the Arnab Ganjan Goswami, my lord, and versus Union of India. Yes.
Which basis of the FIR?
Well, FIR is an annexure 2, page 21. The relevant portion is that, my lord, page number 26.
Yes,
May I read, my lord?
second FIR.
This is the first FIR, my lord. The officer in charge.
Second FIR.
Second FIR is at page number 28, my lord, and the relevant portion is at page number 32, my lord. May I read, my lord?
No. Only two FIR?
Well, third is at page number 34, my lord. FIR is not available, my lord, only this. I have the screenshot of the social media report, my lord, here. Which speaks that trouble depends for Jorhat-based journalist Utpal Bora as the FIR has been lodged against him at Badarpur police station in Sri Bhumi district. That was also lodged the same day, my lord. So it's on 23rd. 23rd and 24th September. The issue here is also same, my lord.
Okay, which is the second case you are referring to? First is that King Thomas. What is the second case?
Arnab Ranjan Goswami versus Union of India and others. The reported your lordship in 2020-14 SCC 12. This is directly in the writ petition criminal number 130 of 2020, my lord. The relevant para, my lord, page para 7, my lord. Sorry, para 8.
Yes, sir.
Second test register, Jorat. Second test Jorat of course. Register Dila Jorat. First second, very highly, very highly good. Second two. You know, practical leader. Mohit Kumar Bora. First one, very well. First one, police officer. Police. It's 6 days.
Mr. Hazarika, who was there for the response? Okay. Yes, Mr. Sharma, what do you have to say?
Lordships, in second FIR, my lord. The lordships is second FIR. Second FIR page 32, my lord. Para 3, he used some such type word against, but my lord, the under the industry, may I read lordships that?
Under this investigation, they influence a part of the large gathering. Thousands of assembled the Borvacharili Jorat created the law and order problem. Some people provoked by him destroy the illegal property. National of in last paragraph, my lord, he used remark and attempt to violate the character of wife Jubin, the late Jubin Garg, namely Gorima Garg, thereby ousting him the story. For that reason, my lord, one Manoj Borua, he filed that FIR. That is the main problem.
My lord, here, my humble submission, my lord. I stay in my para 9, my lord. That I have just stated one line here. That Zubin Garg is not only the property of his wife, he is the property of entire state. That line has been in a distorted manner, has been circulated in the social media, and thereafter some narrative stories has been come out. Basis which this multiple FIRs have been lodged against me, my lord.
He has no rights.
This para 9, my lord, here I have stated here. What? Actually, my lord, I was not in the part of this protest march, procession, my lord. I was sent there by the request of the district administration. The deputy commissioner asked me to go and pacify the crowd there. As I am a journalist in that particular area, I was known to all there. So there I visited on request of the district administration and I addressed the crowd there. Please remain calm, and then I addressed one line there that Zubin Garg is not only the property of his wife, he belongs to the entire state. So we have to
used some.
We have to go by the whatever the state government decides.
You're Mr.
A.K. Gogoi.
Mr. A.K. Gogoi, learned counsel for the petitioner, as well as Mr. P. Sharma, learned additional senior government advocate appearing for the respondents. Next para. By filing this repetition under Article 226 of the Constitution of India, the petitioner is praying for directions for consolidation of the clubbing of multiple FIRs relating to the same incident, being Jorhat Police Station case number. Jorhat case number 500/2025 under section. You take it from page 2 of the petition of the BNSS, Puli Board PULIBOR PS case number 122 of 2025. As well as social media report of an FIR being lodged against the petitioner at Badarpur Police Station. Next. In this repetition, it is projected that the petitioner come out of deep emotion, sentiment and love towards a particular deceased person, demanded that his last rites be performed in his native district. Accordingly, a large group of persons came and started protesting by blocking roads and forcing shops and business establishments to shut down. And a section of unruly youths also blocked the national highway, preventing the movement of vehicles. Stop. This is the incident of which date? 21/9.
21/9.
This said incident occurred in 21/9/2025. The petitioner projects that he is a reporter of a news channel and had posted a live video on a social media page. Stop. It is projected that the said social media post incited people to gather and resorted to protest. Stop. Next one. In connection with the said incident, the officer in charge of ISBT PP is police outpost. PP on 23/9/2025, lodged an FIR with the officer in charge of Puligor, PULIBOR, police station, Jorhat, referring to ISBT PP GDE number 361 dated 21/9/2025. Accordingly, Puligor PS case number 122 of 2025 under section so and so from page 2 was registered. Next one. On 23/9/2025, one Manoj Kumar
Bora.
BURAH, also lodged a separate FIR before the officer in charge of Jorhat police station, which was registered as Jorhat PS case number 500 of 2025 under section so and so. Which is stated to relate to the same incident of instigation to people which led to a large gathering at Borua Sariali, BORUA, Sariali, CHARIALI, Jorhat, leading to illegal blockage of national highway and disrupting public order. Further alleging that the petitioner had made derogatory remarks and attempt to malign the character of the wife of the said deceased person, or thereby outraging her modesty and reputation. Next paragraph. The learned counsel for the petitioner has submitted that the FIR was lodged at Fatherpur police station However, he has not been able to collect the copy of the said FIR. Stop. However, it is there. It is submitted that the same FIR also relates to the same incident. In support of his submissions that multiple FIRs could be clubbed, the Learned Counsel for the petitioner has cited the case of T.T. Thomas versus
Pretty Anthony.
T.T. Anthony versus State of
State of
Kerala within bracket 2001, bracket close 6 SCC 181, Arnab Rajan Goswami versus
Union of India and others.
Union of India and others within bracket 2020, bracket close 14 SCC 1-2. Next paragraph. Per contra, the learned additional senior government advocate has submitted that though the two FIRs have been lodged on the same date, i.e., 23/9/2025, but the contents are different. Full stop. It is submitted that in the FIR relating to Jorhat PS case number 500 of 2025, the issue of derogatory remarks thereby outraging the modesty and reputation of the wife of the deceased, and the act of promoting enmity between two different groups were not in the other FIR of Pulibur PS case number 122 of 25. Next paragraph. We have considered the submissions made by the Learned Counsel for the petitioner and carefully perused the cases cited by the Learned Counsel for the petitioner. Next paragraph. For a comparative reading of both the FIRs of Pulibur PS case number 122 of 2025 and Jorhat PS case number 500 of 2025 quoted below. We have to extract this page 26 and page 32 and 33. I'll give it a tick mark. That's it. Next paragraph. In the social media report regarding the lodging of a file before Badarpur police station, it said social media post only states as follows: inverted comma start. Trouble depends for Jorhat-based journalist Utpal Bora as an FIR has been lodged against him at Badarpur police station in Sri Bhumi district. This was comma post. Next para. The question that rose in the case of T.T. Anthony within bracket Supra is number one. Effect of the subsequent FIR, the subsequent or second FIR lodged in the matter. And the said query was answered in the negative by holding that second FIR is not permissible for the same subject matter. So the second question which arose in the said case was whether the accused can ask for question of the criminal proceeding. Which was answered in the affirmative. Next, in the said case, of T.T. Thomas within bracket Supra, the second FIR in respect of the same incident and on same facts was registered after about 3 years. Full stop. You have a printout of that T.T. Thomas. It's very difficult to find out in the copy. You have a printout. Just give it.
Well, they are taken it from Supreme Court website.
Whatever we please give it.
Yeah. There's one side pending only, madam. YouTube did you go?
Or there is a on a perusal of the said judgment, it appears that the learned single judge of the High Court had quashed the FIR being registered as crime number 268 of the 97 of Uthu Paramba, AUTHUPARAMBA police station. By ordering that as against the Assistant Superintendent of Police, the FIR be quashed. However, fresh investigation was directed by the state police. Full stop. Thereafter, the second FIR had been lodged, being FIR number 353 of 94 and no, not 3. No, thereafter, however, the earlier FIRs, FIR number 353 of 1994 and FIR number 354 of 1994 being the first FIR. Event on record. Stop. The next para in the said case, the Supreme Court of India had held that for the first FIR, all other informations made orally or in writing after commencement of the investigation into the cognizable offence disclosed from the facts mentioned in the first information report and entered in the station house diary by the police officer or such other cognizable offences as may come to his notice during the investigation, will be statements falling under section 162 of the CRPC. Full stop. It was further held that no such information of the statement can properly be treated as an FIR and entered in the station house diary again, as it was in effect the second FIR and same cannot be in conformity with the scheme of the Criminal Procedure Code. Full stop. However, the Supreme Court of India further observed to the effect that the said order would not preclude the investigating agency from seeking leave of the court in crime number 353/94 and crime number 354/94 for making further investigation and filing a further report or reports under section 178(3) within bracket 8 of the CRPC before the competent magistrate in the said case. Who's talking? Next paragraph. In the present case in hand, comma, on the same date, 2 FIRs was lodged under the jurisdiction of different police stations. Next paragraph. In the case of Arnab Ranjan Goswami, within bracket Supra, news item was aired, AIRD, aired on television channel in relation to an incident of mob lynching of Hindu monks. Who's talking? Alleging that the airing of the said news propagated views which are communal in nature. First of this gave rise to institution of numerous complaints. So I know. It may be mentioned that one of the aspects which was common in the multiple FIRs was the issue of defamation. And with regard to the legal position of defamation, the Supreme Court of India had held that you can get the book SCC 2020 14 SCC page 1-2. We don't know it. Get the books. accordingly, the FIR which was lodged in NM Joshi Marg Police Station in Mumbai was held as to not to cover the alleged act of criminal defamation. Most of the other FIRs were crushed. In with regard to the lodging of the FIR at various states, the Supreme Court of India observed as follows. This is a gap, I'll give it to you. I don't have the book, I just can't find out. Next one. No, because in the absence of book, I can't readily find out the observation in the various states where the FIR was filed. Because the Supreme Court in this case refused to quash few FIRs. Few were quashed, few were not.
No, here the last paragraph. Page 50.
It's difficult to find out here.
No, this is the copy of it. Right, okay. At page 50, para 51.
What did it say about the FIRs in different states?
No, they have all are clubbed together considering in one single, this NM Joshi, Mumbai. All other FIR has been quashed, my lord. That is quashed by the interim order, my lord. Initially at page 2, my lord. My lord, page 2, my lord. Sorry, page 7, para 8.
You can find it out. Just say, so therefore, the fact remains that all the FIRs related to the statements which contained in the program aired in the news channel. Next one. In the present case in hand, in the FIR which was lodged as Pulipur PS case number 122 of the 2025, from the contents of the FIR, which is extracted herein before, it is noticed that the said FIR was filed by the officer in charge of ISBT PP, alleging unlawful assembly which obstructed the movement of public transport on emergency vehicles and general computers, causing serious inconvenience and danger to public safety. Full stop. It was alleged that the mob raised slogans and created obstructions, thereby willfully disrupted public order and peace in the area. Moreover, the persons participating in the mob tried to molest female police officers on duty and also assaulted officers and personnel on duty. And the unruly mob tried to vandalize police vehicles of offences and personnel on duty. And the mob pelted stones on police, on duty police personnel, causing injuries of the personnel on duty and potential threat of damaging the public vehicles running the national on the national highway. And moreover, the mob had also brought tires to burn on the national highway as a mark of protest. First off, despite despite persuasion by the police and district administration, some of the crowd did not disperse. Insofar as the other FIR is concerned, not only the disruption of traffic in the national highway was highlighted, but it also referred to the derogatory remarks and attempt to malign the character of the wife of the deceased person, thereby outraging her modesty and reputation.
And paragraph 4 also, my lord, I have forgotten earlier. He is the past remark against Utpal Bhara earlier made a remark against this late.
Earlier it's
4 also, my lord. If I,
and he also referred to the
yes,
earlier derogatory remarks against the
late Jamindar.
concerned deceased. And it is alleged that the act promoted enmity between different groups and followers of the said deceased person, affecting public harmony. Full stop. Next, the contents of the third FIR is hitherto not known or disclosed before the court. Next. Therefore, the court finds that the ingredients of two of the offences are dissimilar, except for the traffic obstruction in the national highway. Full stop. Therefore, as a distinct offence has been made out in the second FIR, being registered as Jorat case number 500/2025. The court is disinclined to invoke extraordinary jurisdiction of this court under Article 226 of the Constitution of India. Order to out of the proceedings. Next paragraph. However, for parting with the records, the court is inclined to observe that under the provisions of (242) of the BNSS, 2023, which corresponds to the provision of section 219 of the CRPC, it is provided that officers of the same kind within a year may be charged together. Accordingly, the petitioner is at liberty to produce a certified copy of this order before the concerned police station to bring to their notice regarding the registration of multiple FIRs, so that by invoking the provisions of Section 242 of the BNSS. Comma. The police, I of the case, I of the FIR which is lodged first on the point of time can frame, can charge the accused together for the multiple FIRs insofar as the common ingredients in the FIRs are concerned. Full stop. Next paragraph. Nothing contained in this order shall preclude the right of the petitioner to make an appropriate application for quashing of the FIR, comma, is so advised. Post with the absolute set observations. Comma, this petition says closed at the motion stage without issuance of notice on the respondents. Okay, so that was done. We'll take this back with the books. CC.
Live.
We can take this back.
Item 8 for motion.
May it please, Your Lordship. Lordship, opinion is at page number 39 in
24.
dated 8/10/2024, Your Lordship. Lordship, it was filed on 31 of October, Your Lordship. 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 A. Rahman.
The counsel for the petitioner and so also for the respondents. The opinion is at page 39, dated 8/10/2024, passed by so-and-so in case number so-and-so. By declaring the petitioner for the following of post 25 to 1971 street. Notice returnable on, we give a returnable date, returnable on so-and-so. Extra copies within 2 days. The relevant records be called for from the concerned tribunal from the following email addresses. Next, the prayer for bail shall be considered on receipt of tribunal's records. Next paragraph. In the meantime, if the petitioner, namely Musamad Joida Khatun alias Zaida Khatun alias Zaida Khatun is apprehended, comma, she shall not be deported out of the country without order of the court. Next paragraph. If petitioner shall cause production of a certified copy of the order before the Superintendent of Police. Bongaigaon. Bring the notice to the order to the notice of the said authorities. List on so-and-so.
Highly obliged.
8 January. Item 9.
May please, Lordship. So by my opinion,
dated 28th of March 2025, my lord. Lordship will find it at page 69, next IM, my lord. Petitioner has been declared as a foreigner.
Mr. Yu Das, Learning Counsel for the petitioner, and so and so for the respondents. Opinion is page 69,
My lord.
dated 28/3/2025. Filed by so and so, in case number so and so, reference number so and so. They were declaring the petitioner to be a foreigner post 25 in 1971 stream. Notice returnable in 4 weeks, extra copies in 2 days, call for the following email address. Here for bail is opposed by the learned standing also for the FT matters. This is the projection, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border.
Walpam.
Okay. So in this orders, don't write usual process. Issuance of notice for or calling for the record, the usual process. Omit that usual process. Continue after that.
Supplementary item 31.
Yes. Oh, I am sorry. Some mishap happened. It couldn't be ready today. Fix it 1 or 2 days.
Yes, my lord.
We are sorry.
No.
Supplementary item 32 for motion.
My pleasure. Impugn order, your lordship, page 103. Order 18/6/2025, that declared the petitioner as foreigner of post 97.
Page number?
103.
We are giving bail. So S. Islam, Learned Counsel for the petitioner, opinion at page 103, dated 18/6/2025, asked by so and so in case number so and so, IMDT case number so and so, thereby declaring the petitioner to be a foreigner. That's notice returnable in 4 weeks, extra copy within 2 days. For the records, the following email address of the learned tribunal. It's for the prayer for bail is opposed by the learned standing person for the FT matters. Assembly conviction, 10 days time to take bail out of this 5,000 in satisfaction of Superintendent of Police Border, Borpeta.
Borpeta.
This sort of forms.
Oblige.
Item 33.
We should be 75. None appears on call for the petitioner. Powers for the respondents are present. I heard so and so for the respondents. Opinion at page 75, dated 15/11/2025, passed by so and so in BNGN case number so and so, IMDT case number so and so, thereby declaring the petitioner to be a foreigner of 25/3/1971 street. Same order. Bail, bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Bongaigaon. List after 4 weeks on receipt of reports.
Supply item 34.
Please also, my lord.
Input order page 107. And accept.
Here is same order, Bailey. Mr. Zaid Hussain, counsel for the petitioner, for the constituency for the respondents. Page 107, opinion dated 16/8/2025. Passed by so and so in case number so and so, police reference case number so and so. Declaring the petitioner to be a foreigner of post 25 to 1971. It was giving bail of rupees 5,000 to the satisfaction of Superintendent of Police Border Dhubri. List after 4 weeks on receipt of records. Copies within 2 days.
Obliged.
Upgraded item 27.
We have filed it. Today I have filed it.
You got it on record.
No, no.
You take it up day after tomorrow. We need to have that. Both sides are represented. Leonard Standing Council for the IT and Border Matters has submitted that an affidavit has been filed. Today,
Yes, Lord.
so however, the same is not on record. The registration type the same with list on 17/12/2025.
Obliged.
Upgraded item 28.
Wait, Lordship. Lordship, kindly pass over for the time being. Pass over for the time being. Senior counsel election.
$29.
Your Honor, my senior is in legs. Can it be taken after some time?
After vacation, otherwise.
Let's stop.
The IA is required consideration.
This is only an IA.
But Lord, I am opposing, my lord. This is not a registered organization, my lord, no authority, my lord, no code that has been shown. What purpose they would like to participate the proceeding. Therefore, my lord, I have objection.
Then we'll take it up. This IS should not be kept pending. Take it out sometime. Maybe order, may not be ordered, but we don't keep these matters pending
No problem.
after some time.
Time being, sorry. Upgraded item 30.
May I please, Lordship, can you pass over for some time?
Supplementary item 38.
My pleasure, Lordship. My lord, in this case, directed to appear before the Superintendent of Police Bozali. It should be Superintendent of Police Borpeta, my lord. He appeared before the Bozali SP, my lord, but they informed that case record is pending before the SP Borpeta, my lord. SP Borpeta. Lordship.
Yes, Lord.
Petitioner, as well as transfer for the respondents. By filing this interlocutory application, notification of the order dated 3/12/2025, asking WBC 6878 of 2025 has been paid for. It is submitted that the relevant records are available in the office of the Superintendent of Police within bracket border, bracket close Borpeta. Which is carried as respondent by 8. Accordingly, comment is submitted that when the applicant had appeared before the Superintendent of Police within bracket border, Bozali within bracket respondent number 7, is directed to go to the respondent number 8. Next one. Having heard the standing counsel for the AP and border matters, this interlocutory prayer made in this interlocutory application stands allowed. The reference to Superintendent of Police within bracket border, bracket close Bozali, appearing in paragraph 6 and 6, 7, and 8 of the order dated 3/12/2025, passed by this court in WPC 6878 of 2025, shall now be read as Superintendent of Police within bracket border of the. Accordingly, the time for the petitioner to take bail before the Superintendent of Police within bracket border, because Borpeta is extended by further 10 days from the date of this order. Accordingly, this order shall be read together with order dated 3/12/2025, passed by this court in WBC 6878 of 2025. Next, this the application stands disposed of.
Supplementary item 35 with item 36 upgraded.
I mean, item number 36, my lord. I file and my lord additional affidavit, page 34, my lord. Page 34, my lord, I file an additional affidavit, my lord.
Yes, sir.
Yes, my lord, regarding my lord, para number 2, my lord, paragraph 4, my lord. In the read petition, my lord, inadvertently, my lord, it was written, my lord, at page 4, my lord, my read petition, para 4, my lord. Page 4, my lord, paragraph 4, my lord, of the read petition, my lord.
Just a moment.
Beg apology, my lord, I made.
Just a moment. It's paragraph 4 of the writ petition. Yes.
My lord.
Mr. Rahman, I'm not being able to follow you. What you are trying to say?
My lord, my read petition, my lord, page 4, my lord, my read petition, my lord.
Page 4.
Yes, item number 6, read petition number 5498, my lord. Page 4, para 4, my lord. Can you see, my lord? It is, my lord, inadvertent mistake, my lord. I beg apology, my lord.
You are asking us to refer to
Yes, my lord. That time, my lord,
5498.
I filed, my lord, additional.
No. You are asking us to look at page 4 of which writ petition?
5498,
5498.
my lord.
Page 4, paragraph 4.
My lord, para 4, my lord. Well, it's my fault, my lord. So, my lord, I have filed an additional affidavit that clarifying that, my lord, at page 34, my lord, of the additional affidavit. I file an additional affidavit on, my lord.
Yes. 4th December. 4th of December.
4th of December, my lord, I filed additional affidavit, my lord. That is at page 34, my lord.
Running page.
Running page 34, my lord. My lord, inadvertent mistake, my lord, I beg apology, my lord. And there was an order also, my lord. Until further order, the petitioner shall not be deported out of the country, my lord. But I'm being detained. Now I am at my lord, Kukrazar holding area, my lord. A detention area by the police, my lord. I'm not at Matia, my lord. So, my lord, my land plan will file a petition, my lord, for seeking bail, my lord.
Reported. Again, she was sent back. Yeah. But habeas corpus filed, so government delegation. No, clarify. Affidavit to. Yes.
Lordship, if we coming to repetition 5498 of 2020, Lordship,
If we see the impugned opinion, Lordship, page 10, Lordship. The notice was also sent to the permanent address of village Tivstan, PS Ambagan district, so and so, who is,
No, he is not disputing the receipt of notice.
ah,
What he is now
yes, okay,
saying,
he appeared, Lordship.
what he is saying is that the statement made to the effect that he did not appear, he did not contest the proceeding which is in the writ petition. That is a mistake of the government council. That is what he is saying. That statement is at paragraph 4, page 4 of the writ petition, 5498. Now he says that this is a mistake.
Petitioner being a layman does not know the process and law, being ignorant, but Lordship, she was appearing in the case, Lordship, and there is no specific explanation why she approached the High Court so late, Lordship. Why she approached the High Court so late, Lordship? There was no specific, because impugned opinion was passed in the year 2015, 29/10/2015.
I'm being detained, my lord. I'm being detained now, my lord.
Prior to that, she was under detention. Yes.
Prior to that, my lord, I was in detention camp for last 2 years, my lord. And my lord, Indian authority has sent me to Bangladesh, my lord. Again, Bangladesh police sent me back, my lord. Hmm? My lord.
Yes, Miller.
My lord.
The present affidavit
Yes, my lord.
is by one Sultan.
Sultan is the son of,
Son, my lord.
son of the detained.
Say that my father say.
My, his mother, my lord.
Mother, my lord.
My lord, his son on behalf of his mother, my lord. She's under detention, my lord.
See.
My lord, to clarify, my lord, I'm in detention camp. That's why, my lord, my son has, my lord, filed his affidavit.
The petition
My lord.
was by the mother.
Yes, my lord.
Who's filed the affidavit? Check that.
Yes. Nasiruddin, my lord.
Nasiruddin, husband, my lord.
Husband. Yes.
Say, father made a mistake in the affidavit. Can you come and say? You see, it's like you both are just running here.
My lord, he has been authorized, my lord. He has made a specific environment.
Can give you instruction. I can give you,
My lord, my lord.
Supposing in a case you are signing. A and B, you're not saying you. You know, so A and B are two persons. A's affidavit, he is coming and saying that it is wrong. If they accept it.
Since the matter belongs to the same family and he's the son of the, my lord,
same person, my lord. We have seen many cases where even the father and son are not in talking terms. In fact, the my lord habeas corpus.
Then my lord, I pray, my lord, I would do this petition, my lord, the additional affidavit, my lord. And I will file an affidavit by Nasiruddin, my lord.
Yeah, sorry.
Some model check here, sir.
By affidavit.
Yes,
I see. My lord, may I submit 2-3 lines, my lord, before your lordship, my lord? My lord. Since, my lord, the mother of the, my lord. My lord, this has been filed by him. Whatever be, I am not saying you miss, I am not. My lord. If you don't file an affidavit, one affidavit cannot be rectified by an affidavit of third party. Yes. And then you say you withdraw it and you file it. You can't allow you to set up the decimal like that. There will be no sanctity of the court proceedings there. My lord, with all respect, I am submitting. Affidavits. Take the affidavits so badly. Lord, the second affidavit, my lord, additional affidavit, why it was filed by the my lord son, my lord. Since the second petition, my lord, the habeas corpus, that was preferred by the son and he was authorized to, my lord, file the my lord, habeas corpus petition. Therefore, my lord, probably, my lord, the son has shown the affidavit. Lord, a father has, my lord, authorized his son, my lord, to swear the affidavit on behalf of him, my lord. And Lord, can you give an authority to B saying that an affidavit of A shall be resiled by affidavit by affidavit or affidavit by the other person? No, my lord. Can an affidavit of A be resiled by affidavit by B? No, no, my lord. Then, my lord, then lordship will kindly allow us, my lord, to withdraw this, my lord, additional affidavit, and a separate additional affidavit shall be filed by the my lord person concerned, my lord, Nasiruddin, my lord. That much, my lord, where I am making for your lordship. Lordship will kindly. We both deliberate in the chamber and then pass orders. We can't say which way we would go. But for the interest of justice, lordship will kindly allow us, my lord, this is his mistake, my lord. He will, my lord, swear a separate, my lord, additional affidavit, my lord. You got sufficient, Mr. Ahmad. Last time when the matter came up, we gave you a reasonable opportunity. Yes, my lord. After that reasonable opportunity, this has come. Please tell us. Let us, you forget about this case. You take it upon yourself. You see, you are appearing now from the other side. And we give the petitioner opportunity after opportunity to change the affidavit. Will you standing there in this side like it? That there's a mistake in the repetition. No. Let us say a tender matter where somebody has made a blunder in filing a repetition. Can we allow you to amend the affidavits to an extent which hampers administration of justice? We can't allow that. We are very sorry for before your lordship, my lord. We'll be from next time we'll be very careful. Lordship will kindly grant us, my lord, that much opportunity, my lord. My lord, we are extremely sorry for that. And there's another thing, we must make a word of caution to all of you. Yes, my lord. You see, in this writ petition and in the affidavits, you have sprinkled so much of fragrance of attar that it is disturbing us. It's not a good practice. Yes. I'm sorry. Why you are putting up so much of incense and attar here and presenting affidavits before us? Sorry. It's not a way to please us. My lord, I'm very, very sorry. We were surprised with the amount of fragrance that my sister had to cleanse her hands, which we did in your presence. This is not a way to present. You want to please us by sprinkling attar? You take an exception to it. It doesn't fall from the heaven. Attar is something that doesn't fall from heaven. Somebody must have applied. Look at the brief. Look at the brief. This is not the way to present things before us. It's not a part of the High Court protocol to permit you to fill up this with fragrance and annoy us to an extent where we have to sanitize our hands. Your application. Give it to them. I don't, no, just smell it. You'll find. Just smell it. Oh, in the affidavit, there is an affidavit. Just check it. Give it to him. This is not how things are to be presented. Is that contains atar? Mr. Sharma,
Lordship,
does it contain atar? See that affidavit then, in that proceeding? No, there are two affidavits. See it there.
Somebody might probably use
Somebody does.
have not touched
So much of- such much of fragrance is not sprinkled just
Yes,
by
yes.
somebody. You don't get it for free.
I have not touched the file even How come it will come?
You smell it.
smell is coming, Lordship.
That's impermissible. We'll look into it in the chambers. We take a strong exception to these practices. These fragrances do not, what do you call it, doesn't.
Usually news.
No. Get it in the chambers. We'll deliberate and pass orders in the chambers. Take note of your submissions.
Well, we're very sorry for the moment. We'll be careful next time.
No, in fact, we love it. It gives us a very easy road. Okay, next.
Time being item 28.
Lord, yes. Sorry, my lord, I was on leg, my lord. My lord, a delay continuation in the connected appeal has been preferred, my lord, and the objection has also been filed. My lord, the issue is very, my lord, connected. My lord, there is a delay, my lord, considerable delay, my lord. What has happened, my lord? Initially, by challenging the order of the learned single judge, we have challenged a particular part, my lord, wherein we have been directed to approach the educational tribunal, my lord. That part had been challenged. Now, my lord, what has happened during the course of the hearing, my lord, it has come into the notice, my lord, that the appointments of these private respondents, my lord, though has been held to be, my lord, not in accordance with the law, but their appointment has not been disturbed, my lord. So therefore, my lord, that part is also now we put into challenge, my lord, because, my lord, if they do not vacate, my lord, then though we have been reinstated, but we cannot be accommodated, my lord. My lord. Fuck you. I'm afraid, my lord, due to the, my lord. I don't know what is happening, my lord, all this sequence. My lord.
See paragraph 6 of your.
Oh.
See paragraph 6 of your.
My lord, my lord, this is, my lord, I have কি করেছে that is হাতে দিয়ে লিখিছে যে
617 days.
My lord.
Paragraph 7 is 317 days.
my lord
Uh,
that is correct my lord.
next page. 317 days.
কাকে থেকে delay of 617 days my lord. Originally it should be my lord 617 days, it should be everywhere my lord 607, but it is not here my lord.
Yes, ma'am. Yeah, 10678.
এটা কি দিছে affidavit of reply my lord, it should be 617 days my lord.
670. Okay.
My lord,
My corrections are fine.
my lord, my lord. Fill up to. My lord,
Is it very good time mistakes?
no, my lord, that's why, my lord, every day we are very anxious that if any mistake is committed when we appear before my lord, my lord. Huh?
Here, whether you find any matter.
My lord, my lord, no, that is correct, my lord. Fill up করা না কবার ছাড়া।
What is the ground you are failing to understand? Please explain the ground.
My lord, the grounds we have said, my lord, in paragraph 4 of this reply, my lord, as well as in the miss case. It will not miss.
Your sanction update.
Yes, my lord, that is another ground, and my lord, as the presently, my lord, continuously we are pursuing with another appeal, my lord. That is rate appeal number 3055, my lord.
Then you see you follow within that your own petition. If you are pursuing the another writ appeal,
My lord.
how can this next second writ appeal be maintainable?
No, my lord, what has happened when we, my lord, initially moved the original appeal, my lord, the first appeal, that is rate appeal 247/21. Wherein, my lord, we actually originally, my lord, there were 4 writ petitions were clubbed together and disposed of, my lord, by a common order. Now, my lord, in 4 writ petitions, the prayer and the cause of actions were different, my lord. So therefore, my lord, when the original, all these petitions were clubbed together and disposed of, my lord, the appointment part of this private respondent wherein we have challenged in another case, my lord, that has not been interfered with by this learned single judge, my lord. So that's why, my lord.
Just it will.
ऐसा
Yes.
हाँ Yes, my lord.
Show it from the memo appeal, what you are trying to tell, project in this application.
My lord, yes, my lord, this in memo of appeal, my lord, if my lord may be pleased to take up the common judgment and order, my lord.
Page.
My lord can straight away turn to page number, my lord. Judgment. Page number, my lord, 406, annexure 8, my lord, to this
406.
406, my lord. Now, I straight away like to draw my lordship's attention to the relevant part, my lord. At page 425, my lord. May I read over from paragraph, my lord, 36? my lord.
In the cost title at page 406, who are the present applicants?
Present applicants are there, my lord. Asiruddin. Then, my lord. আমার কোন কোন আছে my lord Asiruddin, then my lord Dewan Muhammad Samsul Alam, Anwar Hussain, Chand Mahmood and Gulam Rabbani. My lord, may be pleased to find all their names, my lord, in this page 406, my lord.
So they are the applicants here.
They are the applicants here also, my lord.
Okay.
Praying for the delay condonation, my lord.
Now you are referring to 425.
Now, my lord, I am bringing my lordship's attention to page number 425, paragraph 36, my lord.
Yes.
May I read, my lord?
Yes.
After considering the entire aspect of the matters, the court found that it is established that the respondent college, before terminating the petitioner from service of the college, did not give any opportunity of hearing to them. Therefore, the impugned resolution of the respondent college dated 9/6/2009 regarding termination of the petitioners from the college being in violation of the principle of natural justice are not sustainable under law, and accordingly they are set aside and quashed. Accordingly, the order of the respondent DHC Assam under number so and so upholding the decision of the governing body of the college dated 9/6/2009 also cannot sustain under law, and therefore the same is also set aside and quashed. As a whole, the termination of the petitioner from their respective services from the respondent colleges being found to be illegal are set aside and quashed. Consequently, the speaking order of the Director of Higher Education Assam dated so and so is upheld. The division bench of this courts in its order dated passed in writ appeal number are hereby observed that the petitioners are not in service from the date of their termination in the year 2009, and their provincialization is subject to the result of the writ petition. The order permitting the eligible staff of the respondent college for consideration of provincialization under the applicable norms and provincialization of those who are appointed in place of the terminated writ petitioner shall be subject to the result of the WPC number so and so is still in force. So the petitioners on or before 39/2021 shall approach the appropriate educational tribunal of the district concerned in which the respondent college is established to raise their claim for provincialization of their services under the provision of the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017, which is in force. In the event of such approach by the petitioners, the concerned educational tribunal, after hearing the petitioners, the concerned departmental authorities, the respondent college authorities, and the persons appointed in the college in place of the petitioners after their termination, that is respondent numbers 4 to 8 in WPC number so and following the criteria, applicable norms, etc. for provincialization as specified in the said 2017 Act, shall pass necessary order in that regard at the earliest. However, it is made clear that the provincialization of the services of the petitioner and that of respondent numbers 4 to 8 of WPC number shall be subject to the decision of the educational tribunal concerned. Now, my lord, this part, paragraph 39, my lord, we have preferred a writ appeal, my lord, which is now pending adjudication for final disposal. My lord, we have in that writ appeal, my lord, our ground is that, my lord, as we have been reinstated in service. So therefore, my lord, under the 2017 Act, the law will take its own course, my lord, and therefore the separate prayer for, my lord, our provincialization in the educational tribunal is not required, my lord.
What is the number of the writ petition?
That writ appeal number is writ appeal of, my lord, 247 of 2021, my lord. My lord can tag also if my lord, my lord. So now, my lord, what has happened? Now, my lord,
No, you see,
my lord.
the applicants herein
Yes, my
are the
lord.
appellants in WA 247 of 2021.
Yes, my lord.
Correct.
Yes, my lord.
But then this also is an appeal
My lord.
against the same order. So appeal will not be maintainable.
No, my lord, same order appeal is there, my lord, but the relevant part of the.
No, that will be hit by order 2 rule 2.
I had to question.
That will be hit by order 2 rule 2 and constructive res judicata explanation 4 to section 11, which applies in the writ petition.
My lord, what has happened, my lord, I have already respectfully submitted before my lord, is that 4 writ petitions were there, my lord. Now, in one writ petitions, the challenge which we have this part, my lord, the part paragraph number 38, my lord, wherein, my lord, this honorable court says that the selection and appointment of these private respondents shall be, my lord.
Sorry, you see,
My lord,
Mr. Bhuya, this,
my lord.
what we are trying to ask you is, let us say that order of the court contains 5 paragraphs.
My lord.
So in one appeal, paragraph number 1 will be challenged. In second writ appeal, paragraph 2 of the order will be challenged.
My lord.
And similarly, 5 appeals, can it come on board?
No.
Then,
That is, my lord, if it is arising out of a one writ petition, my lord, then my limited understanding, my lord, is no. But my lord, here is a case wherein this judgment is a outcome of 4 writ petitions, my lord. 4 different prayers were made, my lord. And all these writ petitions were identically, my lord, though clubbed together, but the cause of actions were decided, my lord, differently, my lord. The cause of action, we are agreed with paragraph number 38, my lord. My lord, I may be wrong in understanding, my lord, but my lord, as
we are
if,
not saying you are wrong.
my lord,
For a moment, we are not saying you are wrong. We are just trying to understand the proposition of law.
my lord, my lord. But my lord, that is correct, my lord. For the one order, my lord, a writ appeal, my lord, an incumbent, my lord, cannot challenge the, my lord, 2 different writ appeal for the one and common order. But my lord may kindly appreciate, my lord, if we do not put into challenge this part, my lord, then their appointment will remain and survive, my lord. There will be, my lord, no other options left, my lord. My lord, we do not have, my lord. My lord can take up tomorrow by clubbing together, my lord. My lord. The prayer which we have made, my lord, in that appeal, my lord.
You see, for the time being, that prayer is, we can't accept it.
My lord.
The clubbing will come only after we issue a notice and then we club it for the purpose of hearing,
My lord.
not for the purpose of issuance of notice. That's one. The earlier appeal, you say that your earlier appeal is writ appeal 247 of 2021.
Yes, my lord, 247, 2020. Still prayer as well, writ appeal. Club provision. It's 12, so one on.
No, your prayer will list it tomorrow,
My lord.
but we are not satisfied because of the
My-
fact that
my-
come to page 1 of your writ appeal.
Page 1, my lord.
Yes,
My lord.
the nomenclature of your first.
Yes,
cost-
yes,
cost-
an appeal against the common judgment and order, my lord.
3 repetitions you have given.
My lord. No, that is correct, my lord, because what has happened, my lord.
Then you'll have to satisfy it tomorrow.
Yes, yes, my lord.
You bring your copy of, we'll rely on your copy of the writ appeal.
If it is in the same nature, my lord, then res judicata, my lord.
We won't say whether res judicata or not. It will be constructive res judicata.
My lord.
Order 2, Rule 2, read with explanation 4 to section 11 of the CPC.
My lord. Yes, my lord. But can it be on Wednesday, my lord?
Wednesday, okay.
My lord.
In courts, in course of submissions, Mr. A.R. Bhuyal and counsel for the applicant has submitted that an earlier appeal against the common judgment and order passed in WBC 6242 of 2012, 6728.
মিস্টেকটো কিয় গম নাজানো তিনটা মেনশ্যন কৰিলে যিটো আমি এগ্ৰিড হৈছো যিটো এলাউ কৰা নাই সেই বস্তুটো দিব লাগিব এইটো আমি কাৰেক্ট amendment no correct মানে cost
Of 2014 and 4760 of 2018 was sailed. Accordingly, as the same common judgment and order dated 18/8/2021 is assailed in the connected unnumbered writ appeal by appeal, on court query as to whether successive writ appeal for the against the same order would be maintainable, on the prayer made by learned counsel for the appellant. The matter stands adjourned today. Mr. R. Islam Lalit, counsel for the respondent number 428, and Mr. Mr. S. Das, standing counsel for the Education Department are present. List on 17/12/2025.
my lord oblige madam
Okay, give a copy.
okay read appeal
Give a copy.
my lord I'll serve my lord oblige madam
Sorry, Lordship, in item 33, I could not remain present. Your Lordship has issued notice and bail also granted, but
Oh, we
none
don't
appear-
know. Most of the orders I have already signed.
Lordship,
I'll have to check up. Just tell me, give a
item
slip to the
33,
courtmaster.
Just call your Lordship, none appears was recorded.
Just give the number to the courtmaster because
Lordship.
till the first half, most of the orders I have signed.
Oblige, Lordship.
Just check it, give the slip to the courtmaster, we'll check it up.
Lordship.
Time being item 29. 29.
I sincerely apologize for the line of delay.
But our eye is for implement, my lord, we want to be an independent in this position and it's a local, my lord, women body of Barpeta sector, my lord. They want to be included as a party respondent to this person.
I have a simple question to ask you.
my lord.
You see, you are agitating the allegation of discrimination of at Borpeta Hotto,
My lord,
where the women are restricted from entering specific areas
my lord,
during religious activities.
my lord,
Now, can we take up this issue at all?
my
Despite
lord,
all these orders passed and the affidavits being exchanged,
my lord.
can we enter into the arena just like that, what happened in Kerala?
Yes, Sabrimala case.
Can we enter into the issue where one should be done? It is a religious practice.
My lord, religious
In
practice.
in my puja, when I am doing,
Yes, ma'am.
without discriminating with any community,
My lord,
I may not allow anybody else to be participating in my puja.
my lord. Yes,
It's my ritual with my deity.
my lord,
And let us say in my house,
my lord.
I'm just giving a illustrative example.
My lord,
In my house, when I'm doing a puja, I may say that even my wife will not stand there. I'll do it myself.
my lord.
Or when my wife does a ritual, she will say that, well, I'm doing my ritual. Please don't come at this moment. 1 hour, give it to me. Don't interfere.
Well.
Now, is this something where I'll interfere and say that in this hotra, they will come, they will not come? Do we have the competence
Well.
to look into the antiquities
Well.
and the religious rites which are being carried out, and then give a judge-made law that X will enter and Y will not enter?
My lord, kindly see that so far the private places are concerned in-house, as lordship said, there is no any problem that whatever one intend to carry out the practice, but so far the public institutions are concerned, my lord.
It's not a
There is a
public
case-
institution, it's a religious institution.
My religious is a public institution, even my lord, it has been looked after by the
I
government.
don't know, under the Religious Endowments Act, it's not a public place.
My lord, so far this institution is concerned, my lord, it is now under the, my lord, the control of and other activities are being looked after by the government itself, even the funded are also being made their own. Now stand is that, my
Irrespective
lord.
of that,
But so
it
far the
doesn't make it
practice,
it doesn't make a temple a public institution.
my lord, so far this institution is concerned, my lord, it is a glaring example that it creates two class of citizens, my lord, in a different footing, my lord. They
No,
cannot, my lord.
you see,
My lord. Yes. My lord. My lord. My lord. My lord.
I say that I want to go there and practice my religion because it is funded, or I have to do something in my manner. Just because it is funded by me.
And there is not a core issue. Issue is that, my lord, the system which they has been adopted, it clearly says that, my lord, it creates a discrimination, my lord. It clearly case of a violation of Article 15, my lord. It is also a violation of Article 25, my lord. And for that purpose, my lord, definitely, my lord, absolutely, my lord. So far, my lord, Sabrimala case is concerned. This aspect has been seriously looked into, my lord. And afterward, my lord, the findings was that, my lord, it cannot be done in that manner, my lord. The same practice was also followed there, my lord. The omens were restricted. Therefore, my lord, the whole thing required my consideration, my lord. And even, my lord, they have admitted in their affidavit that they are not creating a discrimination. This is also very important. The prayer which I have made, my lord. My lord, let the matter be heard, my lord. There is no problem any that, my lord. Otherwise, it is. Yes, my lord. I'm coming. But so far, my lord, my case is concerned, my lord. In 2023, I filed it out. Now, my lord, kindly see their petition, my lord. Their petition.
You are solving the problem, you know.
My lord.
And system of rulings have come.
Yes.
Participation.
My lord, association do not have any objection, my lord. Anybody, my lord, I appreciate anybody's entry, my lord, which otherwise, my lord, important for this case. But question is that, my lord, kindly see, this so far this organization is concerned, my lord. There is no any proof of existence. There is no any authority. Now, even, my lord, this organization even not been registered, my lord. That's why, my lord, I have given one of the judgment on the Supreme Court where it is laid down certain criteria, my lord. That under such circumstances, my lord, how this matter has to be dealt with, my lord. Page 17, page 16, one of the case, page 16, paragraph part of 37. Here, my lord, the same situation has been dealt with under the state organizations issue. page 17. AR 1982 SC 149. Yes, the judgment which I have given, yes, 2006, yes, yes, my lord. And my relevant part is page 17 of the part of paragraph 37, where there is a reference of Gupta and others versus President of India, AR 1982 SC 149. The criteria laid down, my lord. I'm just referring, my lord, that they failed to comply any of this condition, my lord. It is not a registered organization, no authority, no constitution. A good person come in participate, my lord, we definitely welcome, my lord. We want the information from other side, my lord, also.
You are fighting the equality clause of women.
My lord, one woman is already which has been implemented, my lord. I do not have the person.
No.
But so far, this organization I'm
We'll-
opposing.
We'll,
My lord,
Let us say you come and have this legal thing.
my lord,
You have a vested interest. I'm
Well.
not accusing you, but I'm just.
my lord,
Putting giving one to like that.
my lord,
This is bad.
my lord,
You file a PIL saying that you are espousing the cause of women.
my lord.
Tomorrow you concede and say that you are dismissed my activity.
My lord.
I'm just telling you.
Yes, my lord.
I'm not saying this will happen. but I'm
Quite
just
right.
giving you-
Yes, yes, yes.
Tomorrow you come and say that it's my activity.
My lord.
Now, that's the rights of the women to be excluded, is cemented.
My lord, so far this woman representation is concerned, my lord. That is already there. One party is there. I never oppose, my lord. I am only on technical ground. I am opposing, my lord.
Women is in, is a word in plural.
Yes, my
Why
lord.
one women?
Yes, my lord. My lord, I do not have any objection if they are qualified with my lord, certain conditions. My lord, let them come. I do not have any objection. Their information is important. Yes, my lord.
Then you are wanting to exclude.
No, exclude, my lord, on what ground, my lord? I am not excluding any information which is required to become, my lord. Always welcome. I am only on two grounds, my lord. This organization, my lord, there is no any proof of existence. Somebody can,
This women group,
yes,
the conducted reputation,
yes.
do not interfere with their activities, once you exclude them from being included.
My lord, can you see, my lord, I'm only on their petition. My lord, 2023 petition was filed. When they came to know about this, my lord, PL, there is no need, my lord, any whisper in this petition. There is no any authority letter. There is no any proof that this organization is in existence, my lord. Otherwise, my lord,
Then your action we made explicit, they have made explicit right now. For the reason that this is not in compliance with order 1 to 8. You have not, by espousing our cause of others, you have not got leave of this court to fight it in the representative capacity. You are not representing any woman.
my lord, I am
You are
not.
a male. You are not representing the cause of any woman.
My lord, kindly see, so far the grievance is concerned, my lord. It is, my lord, well known to all, my, there is no any, my lord, hide and seek to that. Huh. But, my lord, kindly see that, hey, my lord, I am always welcoming any persons will come and participate proceeding, my lord, welcome, my lord, there is no problem. I am only raising two issues, my lord, that if lordship feel that, yes, it is, my lord, required, my lord, I do not have any objection, but only pointing out only 2 points, my lord, that this authority, my lord, there is no any such thing exist, my lord, and registration is one of the issue, my lord. If lordship feel that their partition necessary, my lord, I do not have any objection to that effect, my lord. I'm just raising my issues, my lord. Otherwise, this case is ready for hearing, my lord. The last occasion, it was, my lord, fixed for hearing. In between, my lord, they enter into their applications. My lord.
It is.
My in PIL, even permission, man, I know exceptional situation, my lord. That's why. Yes, ma'am. Yes, ma'am.
Yes, just a number, he has a finding. You have to amend your first that key. No. Six.
Section 6.
Society. You may come in the name of the president. Because you want to be sued, six of the society, the registration.
My lord, so far as the PIL, in case of writ petition, it may not be maintainable, my lord, but so far as PIL is concerned, I understand society can participate in the PIL proceeding and.
Where is the citation?
My exceptional situation, no doubt, my permissible, my lord, once, my lord, there is a poor or other thing, my lord, that's why criteria is there.
This body of the, my lord, the women of this locality, just surrounding the Borpeta Sattam, they are professing this and practicing this since its establishments.
Maybe prior to independence, but look at section 6. Unregistered society without a suite in the name you can consider it. Or secondary.
And here it is said, my lord, every society registered under this act may sue or be sued.
Unregistered society. Maybe you read yourself without disclosing your particular, because you are wanting to be sued. By starting as the respondent. You are in the second part of section 6.
Yes.
You are
Provided that
suing
it
in
shall
the
be
name-
competent for any person having a claim for demand against the society to sue the president or chairman or principal secretary or the trustees thereof, if on application to the governing body, some other officer or person be not mentioned to be the defendant.
It just shows the case where it has been said in the PIL, registered society can be.
But then I can come up with that there are judgments. my lord.
There is, I
But
also
writ
agree, my
petition
lord.
cannot be.
I also
Petition-
agree, my lord.
Writ petition
Unre-
cannot be.
unregistered, no, my lord, unregistered, my lord, but question that in certain circumstances, my lord, only once, my lord, a person cannot approach to the court with because of.
Citation.
My- My,
Yeah, because the only movements, for number of feelings, of 58 dollars. 56 now, 56. They are on to the funding, on this now, official as for the Satras, we are for the Satras. 56.
3, 4, 5 and so.
And this 7. Three. 7. 7. Where's the? Question. The about 20%. It's referred in the case of P stop street river, yes, NIPE with its state. D versus Karnataka urban by and village board employees. Association and others. Should be, C, 7, 8, 9. That's something that. Cannot maintain an application. Towards the end of January. Some difficulties on my first. Twenty-eight.
Well, much.
Time being item 30.
Please, your lordship. Lordship, this matter may be taken up in some other day, lordship. And legal counsel is engaged in some other court, lordship. Deeply obliged.
Admission item 10 to 17.
There was a prayer for adjournment. Let us look at the records and then pass orders. My
My lord, this in this series, my lord, I'm leading the case number, item number 12, 13, and 15. And
No, at least 4 or 5 prayers for adjournment will come in the morning. We
my
did
lord,
not allow it because of the fact that since these are old matters, we wanted to go through the records and then pass orders for adjournment.
my prayer is that why all these matters are tagged, my lord, should be
No, there must
segregated,
be a judicial order.
my lord.
There must be a judicial order because all this common orders have been passed in the cases.
My lord, item 15.
You see,
15 should
we
not be,
tell
my
you,
lord.
for example, in item number 10, there's an order of 7/4/2021 that lists this matter 5455 of 2016 after disposal of 6736 of 18. Now you see, this is leading to a problem whereby old pending cases are being kept in the registry in the cold storage for quite a long time.
My lord.
We don't want that to happen.
My
That is
lord,
why-
at least, my lord, 15 should not be with this, my lord. 15 is Gwalpara case and others are Dhubri case, my lord.
No, we don't know, but there are judicial orders to tag it together. Item 15 is writ petition number.
My lord, 15 repetition was 7710/2016. Should not be with the other.
Let us see.
My lord, in item 12 and 13, they are husband and wife, they may be tagged. And some documents are common, may be tagged.
You see, judicial orders, we are very difficult.
There is no reason why 15 should be with this case, my lord. That case is of Gwalpara.
Look, it is your own prayer.
My lord,
It's your own prayer. Look at the order.
My lord, 12 and 13 maybe,
No, we
because
don't
they are
do that.
husband and wife.
Judicial orders, we are not modifying it just like that.
Yes. My lord.
এটা আপনার এই
Husband and wife.
No, we don't know. We just want. to
Husband
change
and
the
wife,
records
therefore we are,
because
I made.
more than 200 cases are pending where the next dates are not fixed. So therefore, I am not passing orders mechanically to adjourn the matters. We want to look at the every record and then pass orders. We must know what is happening. Just send back that record.
My lord.
Item 10. This is. Level 5. Yes. This are separate orders. In item 10, say both sides are represented on the pair made by learned counsel for the petitioner. The matter stands adjourned today. Stop. It is made clear that on the next date of listing, the matter would not be adjourned. To stop list on, give that date blank, we'll keep it after some time. Item 15, then item 16 is 7818. It does 7818. It will see a set. HRS, just at this, check all together. What is it? 5477. Huh? No, no. But this is a 5455. 5455 PCL लिखा है सर बस एक लोग कर इट्स रेगुलेशन पुलिस मुझे पुलिस स्टॉप Next is item 11, 4164. Same order. 4164. Said we'll carry it. I hate the word system. It was 16, he said. 19 is a disposed of. Yeah. What the panel? Then 13, 12, 6735. Six, seven, three, five, you are ready to do this matter?
My lord, we are ready, my lord.
No, because then we are not joining on your prayer. We just adjourn it because of the group.
My lord.
Mr. A.R. Siddhan and counsel for the petitioner submits that he is ready for the hearing. So how as the connected matters have been adjourned, list this matter on so and so.
My lord, item 13, the judicial order is, my lord, 13 and
No, just-
12 and 13, husband, my prayer is to take up these two matters together.
Okay. Now this item 13 is 6736.
We got a 6, 7.
6733, same order, 6736. Yeah, the matter. He also praised that the matter be taken up along with WPC 6735 of 2016. Rest of the order will be same. Okay. Now. Next is 15. 7023. Item 14.
14.
Item 14 is John on the prayer and council. Matter will not be adjourned on the next date of listing. List on. Then 7710.
Yes.
Same order, Mr. Siddharth. Here, this is not to be tagged with another record. Is it? The matter is John to be. Yes, then it will be 7817. Such as a representative on the prayer made by and counsel for the petitioner, the matter stands adjourned today. Next column. It is noticed that by order dated 31/1/2019, the court had directed that this matter be listed after disposal of WPC 6736 of 2016. Stop. Next paragraph. However, the same has resulted in a long gap regarding its listing. Next, but accordingly, list the matter on the blank 6786817. It will over 6817. The next matter, 6618. Here, same as last order. I ordered it 31/1/2019. Therefore, it has not been listed according to the listing patterns also. Last order to last case to last week petition. Last order is to 6618. Yes, item 18.
Item 18 for admission.
You filed it today.
Yes,
Okay, looks as a representative. The government counsel for the respondent has submitted that the affidavit in opposition has been filed today. Next one. Let the said affidavit be tagged with record, list on 7/1/2026.
Item 19 for admission.
May I please, Honorable Court, my Lord, lady?
Yes,
Look, this matter arises out of the bones creak in the morning when I make my way to court, my lord. So I prefer to remain seated where I am. Sending the youngsters on scurrying legs, my lord, to be before my lords. My lord, when it comes to horses, I'm very awake, my lord. Otherwise, with the traffic and the dust in the air and the AQI, my lord. My lord, even our Kharguli, thanks to the mist from the river, some breathing space is there in the lungs, my lord. Even commented by so many people in the newspapers nowadays, my lord. My lordship, the FT's order of 31st October 2016 declared me a foreigner. So I appeared before this honorable court, my lord. My lordship said earlier upheld the order. I went to the apex court and thereafter I was allowed to file a review, which was allowed because certain documents are not considered by the FT, my lord. Those documents would show that actually my date of birth was, I was born at home, so there was no date of birth. So my Aadhaar card is, my lord, after the writ petition was dismissed, I went to the apex court. The apex court allowed me to file a review. And with a liberty to arrive, to approach the apex court again whenever required. because the documents which were not regarded by this court, my lord, and which is not regarded by the FT, was filed before the apex court and brought in by my review, which is why my disposed of review is here. My disposed of review is here also as part of the record. I could not file them separately, my lord, because I'm appearing this matter, my lord, as a it's an inherited matter, my lord. I'm now pro bono in the matter. My learned friends who were doing the case, my lord, the original records also were not given. So I put all the required documents. I'll summarize the case in 3 sentences if my lordship would permit me. My parents brought me when I was on hip in the year 1955 or so, when I had no voice to protest coming from East Pakistan, my lord. In 1956, my father and his brother purchased land in West Bengal and they started farming. I grew up, and in Cooch Behar, I was brought as a bride to a gentleman who was from Doboka, Assam. My lord. The only benefit we can take, my lord, is that the tribunals ought to be set aside. Because even under CAA, I would not be a refugee within the meaning of the term. The only thing was that I was before my lordship because the proper documents were not seen by the tribunal. The tribunal, in fact, having examined my evidence and affidavit, cross-examined me in Hindi, which is a language I didn't understand, my lord. So it is recorded whatever and declared me a foreigner. So that diversity, transparency is required, my lord, in the proceedings. So my friend Mr. Sharma would support me when I have actually been in the country. My children have. During the proceedings, my lawyer was not there. So the tribunal, my lord, spoke to me in Hindi and recorded it in Assamese. I am from the Bengali community of Boroi. I'm illiterate, my lord. So I have no idea about what the proceedings were. But my 2 children who were born here, their date of birth and all is recorded. One of them, in fact, works for the Municipal Corporation of Daboka. My husband brought here. I form part of 2 voters lists, my lord. Yes, my lord.
Tribunal. And
my lord,
look at this.
the sale deed of my father, I could not produce properly, so I produced it before this court, my lord. It's listed as Annexure 2/2 in the writ petition. And what was seen by the court was Exhibit 1 in the tribunal below. That's a sale deed from Ranaghat, 16th March 1956, recorded in the book volume 72, page number so and so, my lord, which was brought by the thing. So, as such, my family and myself have been in India.
This is a defect. We can't cure it. Allow you to cure it now.
My lord,
Look at the. You have seen the Exhibit 1.
Exhibit 1/1, my lord. It's the incorrect actually sale deed. I was
It's
able
not
to.
the sale deed. Look at the document.
My lord.
This is a defect. We can't allow you to cure it now.
So this happened, my lord, this long stretch of time, and when the tribunal examined it, it was on that presumption of Section 90 of the Evidence Act, possibly, my lord.
When you produce a certified copy, that benefit you don't get.
That certified copy was produced, my lord, by me subsequently. Yeah. My lord.
This is Exhibit 1. See the next page.
Exhibit 7. This was brought up, certified copy was brought up from Nadia, West Bengal in 2015, Milord.
Get the contents, it is not a sale deed.
Part document, Milord. Yeah, my lordship is right, it's only a part document.
No, no, it's not even a sale deed, not a part.
Milord, you see that the original writ court had relied on this document, and the document that I was saying is a sale deed is, Milord, sale deed dated 16th March 19 bearing 8 to the number is 8258, which I produced before this court. This deed is 4258, Milord, which was relied upon, which is incorrect. What document I had brought was the sale deed was 16th March 1956, bearing 8258 1956 of Banaghat, which was in 1963, which partitioned the land, which was the sale deed of 9834, 1963 Chakra, dated 17 July 1963 was the partition deed. And the sale deed of 1963 could not be produced before the court, was produced before this court as Annexure 2/2 of the writ petition, my lord, of
What you
2017.
produced in the review petition, we don't know.
No, in writ petition, my lord, Annexure 2/2,
But we are showing you the original.
my lord, this is from the original record, which was perhaps.
Then despite the order of the review court, relying on a document.
Because, my lord, I cannot be said to have entered India illegally post 25th March 1971. So the earlier documents, 63, 56, are not even regarded by the tribunal in its proper perspective.
If this is not 56, then we can't be relied on.
My lord,
Even we will not be relying on it.
it is not the document also which I have relied upon. This is a document, my lord, which my counsel may have filed without studying it. Because the numbers are differed.
We don't know.
My lord, even I.
What is there on record, we are referring to that.
My lord, now that is why I am saying, my lord, the record was incorrectly appreciated by the tribunal below.
No, rightly appreciated.
No, what I am saying is that the documents which I show,
You see, that is what we call an improvement, improvisation. That is
not
what-
in my case, my lord, I am too
that is-
illiterate to do something
that
like
is-
that.
That is what we call, you know,
My lord, yes, my lord. My lord. Right. Unfortunately, my lord, there's a little difference to that because this is actually a document that comes out of the green room, which is the record room of the West Bengal sub-registrar, my lord, which actually shows that in 1956 there was a sale deed which has a different number which has been produced before this court.
the statutory jurisdiction.
My lord,
We have limited.
very
boundaries.
limited scope, my lord, but I'm
Limited
asking for an
boundaries.
enlargement. I'm asking for an enlargement that I was never a foreigner of March 25th, 1971.
This is a question which will not come. The reason being that whenever there is a reference, then 6A of the Citizenship Act applies.
My lord, I'm aware.
Therefore, the section 3 would not be excluded by implication.
What I'm saying, my lord, is that the tribunal, based on the unknown source, has held me to be a foreigner suspected who entered India illegally post 25th March 1971. The inquiry which was initiated by the SP, bearing number 2072009, did not even look at these documents. How could I be a foreigner, my lord? Any document which, you know, which say my Aadhaar card was not looked at, my voters list was not looked at, my children's birth certificate was not looked at. 74 onwards would be my wedding. But prior to that, I was a minor, Miller, I was a child. Considering that in the year 1971, if I was born in the year 1954, I would be about 16, 17, even then a minor, my lord. My lord would remember perhaps when we walked into these hallowed halls, we found many of our colleagues had the date of birth 1st of January or 1st of March. So we said, how can you have so many similar birthdays? The headmaster, the headmaster did our date of birth. That was the era then. Now we are in the digital world, my lord. Now we are able to get certified copies with proper, not even handwritten. It's there, part of the recorded system. So, my lord, even if this matter is returned back to the FT and I'm allowed to file my fresh documents, because something has to be done at 72 years of age, my lord. I'm going to a country which I have no knowledge of, if my lordship decides to send me to there. I mean, just on Thursday we had a foundation award where a gentleman from Bangladesh would won. My lordship would allow Mr. Sharma to tell me to stay at home with my children and enjoy my grandchildren. I'd be happy to dangle my grandchildren right now. I'm so terrified. I'm afraid to crawl out of bed. I'm reporting to the SP. The petitioner, my lord, in this case. In my case, I'm yet to be blessed with grandchildren, my lord. My friend would certainly assist the court, my lord, in allowing me to continue to live in my matrimonial home, my lord. I'm a widow now. I'm dependent totally on my one son who's working, the other one is unemployed. There are numerous ailments in the family. So my what I received, my lord, by blessings of God is what I'm getting as an old age blessing now, I should say, my lord. If I go to a different country, I won't get that blessing, my lord. The blessing would only be given to me in Doboka, my lord. District Nagaon. My lord. My lord. My lord. My lord. But I beg to differ with that, my lord, because when I came here to Northeast, I was considered a foreigner. It took me a long time to get my documents to make me a citizen. My lord. I was, in fact, I was termed anything but an Assamese. I was termed as a Nepali also, my lord. Just on the lighter side, my lord. But, my lord, because the condition of the other side of the border, my lord, is very bad at the moment. It'll be like sending me to a death trap. My lord, we've been following, like I was mentioning on Thursday itself, there was a awardee from Bangladesh in one of the foundation awards here. He had been denied a visa by the Indian government. Whereas just now there was a passing out of the NDA where an officer of the Bangladesh army was meritoriously granted. So there is a different, we are not clear about the policies of the government. And here we are with the judgments of the FT, which have to be followed by my friend. My lord, in the next election, I'm a little long in tooth, my lord. We leave it to the younger generation to lead the country now. And the bar and the courts, my lord. Our days have gone. We can only fight strenuously for those that we feel have been wrong, my lord. Perhaps on another day, my lord, we should take up the matter when I'm a little more. Just a short, my lord, when I'll be able to get my lordships convinced that the documents we may be given some time also to make a representation of the government with our presentation of our papers. And my friend would perhaps get a different set of instructions. Then my friend. No, that's right, my lord, because all these documents we presented before the SP, before whom we are reporting once a month. But without any orders, my lord, they cannot even look at them, they say. Some sort of traction may be given, my lord, because it would be condemning me to a limbo, neither here nor there, my lord. If we go by the FTs. Thank you. 28th January, my lord. I'm deeply obliged to my lordship.
Immediately. BC file question. No, copy to issue.
I'm obliged to my lordship, and it is a pleasure to appear before my lordships after such a gap. My lord, I've always appreciated that. My lordship, sister, and I have had long exchanges, my lord. Deeply obliged. In fact, I could not even come to congratulate her at that time, though I called. Deeply obliged to my lordship. Hopefully,
Item 20 up to item 23.
Matter may be taken up on other days. By executing. It will between this.
item 25 for admission.
Yeah, please, please. My lord, impugn order on page 54, my lord. Impugn order is dated 6/10/2022, my lord. Subsequent, after passing of this order, my lord, the petitioner was arrested, my lord, on 28th of May 2025, my lord. Till then, my lord, petitioner at detention center, Walpara Matia, my lord. My lord. No, my lord, here is prayer for bail, my lord. Along with the petition, my lord. There is an interim prayer. My lord. Page 24, my lord. Even my lord, petitioner suffering from deafness, my lord. She could not hear anything, my lord. The DW2 is Gambura, my lord. We should the Gambura certificate. My lord, there is only one thing, my lord. DW1, though my lord, DW1 deposed herself, my petitioner deposed herself as DW1, my lord. But language of the deposition, my lord, it is that, my lord, her son deposed before the tribunal, my lord. But that was exhibited, my lord.
Yes, Lordship. I have seen it. You've seen that? Yes, Lordship. Is it permissible? No, in the Evidence Act, you find what happens to a person who comes and gives evidence.
Yes, my lord, as per section 119, my lord, there is a provision for that type of person for deposition before the tribunal, my lord. But my lord, there is also provision for the videographing also, my lord.
Oh, don't come to that.
My
This video, you never made that clear.
my lord.
And this lady was not examined. So therefore, video recording is not required.
My lord, as per my lord,
This,
initial part, my lord, the examination made by the lady, my lord.
that was never done.
Yes.
This is the above part is written as the evidence of Jorimon Nessa, the petitioner, my lord.
No, you see, this can't apply because of a reason.
Yes,
You
my-
have the Evidence Act with you.
yes, my lord, I have.
See section 1. Plus particular evidence lie in the tribunal. See section 1.
Yes, my lord.
It applies to all judicial proceedings in or before any court. Nobody has held this tribunals to be a court. This is a quasi judicial authority. The spirit of the Evidence Act is required to be followed. And you made a prayer to have your son examined. The problem is that your evidence of your son
Yes, my lord.
doesn't even say that I'm authorized to
My lord,
depose on behalf of the mother.
my lord.
And how will he depose on the basis of knowledge of his mother?
My lord,
That also statement is not introduced.
yes, my lord.
Then this evidence is of no value before us. You check up whether it was a right procedure adopted, Mr. Sharma.
Lordship.
And look at the TCR. At least we don't find anything that the medical certificate was considered.
My lord, lordship, it might have order dated 17/8/2019, my lord.
17/8/2019.
19, my lord.
Petition handling. 77, 79. Can't get advantage. And these are cases where where Mr. Sharma, where your presiding officers must be taken into task. This is the manner in which they are proceeding. Look at page 99. Sending you the records.
Seventeen, 19.
Surveying conditions. 78, 80. Mission of sky is there. Is there any particular place is the
Yes.
correct?
Yes.
From the 99.
Is 99. It is to certify that Ms. Jariman Nessa is suffering from bilateral profound sensory neural hearing loss, and she has been reduced to use hearing aid. Advised to use hearing aid in both ears. Our audiometry report is enclosed steroid.
Yes. So the doctor said that you use hearing aid.
But not used there.
The government says that I have heard that she can't hear.
Yes, looks like.
Then. And this some doctor facility is was. Drop them out. This is not what they want. Send that back. You release our daily, you send that back. You send the records to your home contact. Then examine. This is how your problem was. Thank you. Is for the same thing, there is maybe if we get it from our meeting. After the private, common private meeting. The essence of the certificate business policy. The capital is compensated with variable salary. Very hard. C. Market meetings. Despite use of delegating for years on this described. There are reasons that the device being very. So from the line significantly to deep for power B. The record of the management coming was that. Not accepted. The important like. The this is state of getting. See. That's what we. Petitioner is totally deaf as recorded in the deposition sheet by the Learned Tribunal on 21/12/2021. In absence of any medical records. Stop. Next, it may be stated that the that even with the assistance of it is that as the court could not trace out the petition dated 17/8/2019. or hand over to the Learned Standing Counsel for the Foreigners Tribunal and Water Matters, who also could not readily find out the petition dated 17/8/2019. Please check it up again, huh? Next one. Accordingly, despite objection being raised by the Learned Standing Counsel for the activity in water matters, as the court finds procedural impropriety in the conduct of the proceedings, the court is inclined to set aside the impugned opinion dated so-and-so, passed by so-and-so and so-and-so. Next, consequently, the matter is remanded back for a decision by the Learned Foreigners Tribunal, Borpeta 11th, in accordance with law. Next paragraph. At this stage, the Learned Standing Counsel, Learned Counsel for the petitioner has submitted that the petitioner is about 70 years of age, has been taken into custody on
28 May 2025.
28/5/2025, and is presently lodged at
Matia.
Transit Camp Matia, Gwalpara. The court is inclined to release the petitioner, to direct that the petitioner, namely so-and-so, be released on bail on the following conditions. There are 3 conditions. Next paragraph. The petitioner, who is presently represented by Learned Counsel, is directed to appear before the said Learned Tribunal positively on or before 30 January 2026, and by producing a certified copy of the order, seek further orders from the said, await for further orders of the said Learned Tribunal. Next paragraph. The Learned Tribunal shall make an endeavor to dispose of the matter, preferably within a period of 90 days from the date of receipt of the records. It is 60 days. 60 days with the date of the records. 314. From the date of appearance, the date fixed for appearance. By giving sufficient opportunity to the petitioner to lead evidence in such manner as the petitioner may be so advised. Next, as the tribunal has omitted to appreciate the contents of the medical certificate, which is appearing at page 99 of the records. The Mr. Sharma, we are directing you to send the records back to your channel. And in the meantime, page 99, you take a photocopy, and the order sheet, you take a photocopy, and send it to your home department. Home department. You just say, as it is important that the records are sent back on time, the court is inclined to request the Learned Standing Counsel for the FT, Border and Border Matters and NRC to take custody of the file and to transmit it to the concerned tribunal through the Home and Political B Department. Full stop. Next, as the Learned Tribunal has not considered the medical certificate dated 15/4/2018, the court is inclined to request the Standing Counsel for FT, Water Matters and NRC to send a scanned copy of the order dated . What was it order? 17-8. 17-8, 17-8, 2019. The copy, the photo, the scan copy of medical certificate dated 15/4/2018 within packet page 99 of records. And the deposition of DW1 available at page 38 and 39 of the records to the Home and Political within packet B department. Just to take a call as to whether or not training is imparted to the learned tribunals. Next one. The learned standing position for the FT matters shall receive the reports. By endorsement, making endorsement in the order sheet, in the section in the book. আমি লিখতে না লাগে আমি রেকর্ড দিব কেন বলছো দেখো তো না লাগে দেখো business sense allowed to the extent as indicated above. Next part, there shall be no orders to post. What is it, no? Oh, this will send back. It will send back through you. You're sending it through you. Yes.
Always mail.
You proceed by default.
Mallet. Otherwise, mallet.
Absolutely bad case.
Mallet, bad case, mallet. Immediately mallet. This is not a good case. Obvious mallet.
We do apology, my lord. My lord, for item 28, my lord, your lordship allow us to correct certain inadvertent mistake. So, my lord, I thought that now mistake is still remain, my lord. So, I may be allowed to verify and correct, my lord.
Just 15 to
2 days, my lord. Item 28, 2 days, please, my lord.
this one, 15. Sorry, which item?
Item 28.
28,
28.
1572. Correction for the detail.
My lord, lordship allow us to correct one certain mistake. Oh, my lord.
The correction should not be in the cost title,
My lord.
not in the name.
My lord, only in paragraph, my lord.
Whatever be, it should not be in the names of the parties in the cost.
My lord, my lord,
So for that, you'll have to file an IA.
my lord. Highly oblige, your lordship.
We have no time to take up other matters.